presence of appeal? Can you please?
Presence of accused is mandatory.
Lordship, presence of accused is mandatory, or that is not the question, but
But the appeal is filed through advocate on behalf of accused.
yes, Lordship. But there is legal representation of it, so it can be filed.
No. In case of other cases wherein trial was in presence of accused, it can be presented through lawyer. As far as this case is concerned, exception is carved out under section 356, subsection 7, which says that in case of trial in absentia, accused must be before the court while filing the appeal.
Lordship.
So that is the major defect in your appeal. How this appeal is maintainable?
Lordship, the absence of accused was due to the lowest court, whatever.
Maybe. Therefore you are here for challenging the conviction.
Yes, Lordship.
Your main ground is that it was in absentia, therefore it should be set aside. But filing an appeal, you should be before the court, and you cannot present the appeal only through advocate, and you keep yourself away from the court.
Yes, Lordship.
Now the same threat is not available now.
Lordship.
Continue with the second year.
Your Lordship, the second issue is, did the trial in absentia adheres to due process? Your Lordship, a trial in absentia is an exception, not the rule. It is permitted only in definite circumstances and requires strict adherence for procedural safeguard. Your Lordship, to ensure the accused is not deprived of his right, in present case, the trial court prosecuted unlawful manner which makes the conviction unsustainable. Your Lordship, the legal system is based on the principle that accused person has a right to be present in his trial and defend himself. A trial in absentia can only be conducted in exceptional circumstances. Your Lordship, a warrant, firstly the warrant must be executed against the accused. Secondly, the public proclamation must be made giving the accused at least 30 days to appear. And thirdly, the proclamation must be published in newspaper and at the accused last known residence. So Lordship, before declaring the offender as accused as a proclaim offender, the third point was not followed, that is publication in newspaper, and secondly to circulate it in his last known residence. Lordship, further, the trial did not satisfy the essential before the proceeding in absentia. This appellant was deliberately absconding and reasonable steps were not taken to ensure the presence of the accused before the trial court. Therefore, the proceedings are legally defective. Lordship, in Zahir Habibullah Sheikh versus State of Gujarat 2004, the Honorable Court has held that a failure to accord a fair hearing violates the minimum standard of the due process and remand trial a mere reference. Lordship, also, even the international human rights supports this, as under Article 14 Clause 3 Subclause D of International Covenant on Civil and Political Rights, every accused has a right to present at trial and defend himself personally or through legal representation. Your Lordship, later the Article 10 of UDHR, that is Universal Declaration of Human Rights, it states that every accused is entitled to fair and public hearing by impartial tribunal. Your Lordship, the appellant conviction violates this international principle, further proving that the trial was conducted unfairly. Your Lordship, to conclude this issue, the lower court ignored procedural safeguard, making the conviction legally unsustainable.
Para 22 of the problem. It depicts that entire procedure under all requisites under BNSS were followed. So we have to presume that there was adherence to the procedure provided under section 356. So you remain absent in the trial. Now taking benefit of your own wrong, you are accusing the court as well as the prosecution that they have not followed this procedure.
Lordship, there is
how it is permissible?
Lordship, there is a
And before this questions, for the sake of argument, we will consider that the procedure has not been followed. So because of that, whether this trial gets vitiates,
Lordship, if we
you can answer one for the both.
Lordship, we will think the section 356 provides that the 90 days period must be taken while declaring the proclaim offender.
We said now for the sake of argument, we consider
Yes,
that
Lord.
this procedure has not been followed. Whether the trial has been vitiates in your absence. Whatever trial has been taken place before the honorable sessions court,
Yes, yes.
whether it gets vitiates because of non-compliance of the provisions.
Yes, Lordship. Lordship, firstly, section 375 and section 376 was applied here, and the effect of new laws was on 1st of July. So here they must apply the new laws, but the old laws were applied in the charge sheet itself, and the sentence also was pronounced on the basis of old laws. So this is not adherence of the.
So is it a curable defect is what my learned colleague is asking? Is it a curable defect? Is it a procedural irregularity? Or is it something that completely nullifies the matter and goes to the root of the case?
It is a procedural defect that the charge sheet was framed on the basis of old laws.
So if it is procedural defect, it can be curable. That will not go to the root of the matter. Because you were declared as absconding, there was proclamation. Once there is proclamation by following this procedure, how you can say that your fundamental right is violated?
Adding to that, did you challenge the warrants that were issued from the child? Warrants that were issued against you because you were challenged by you?
Lordship, firstly, in the issue we had challenged the procedural substantive application. So it comes under that point.
No, the warrants that were issued. Were warrants issued against you? Was warrant issued against you?
Yes, ma'am.
Twice it was issued.
And they had
Next point.
Lordship, with your permission, I have proceed for the third issue. Lordship, the third issue is whether the pro-court application on substantive and procedure law was appropriate. Lordship, the Council of Appealment most respectfully submits that the trial court had gravely laid in its application of substantive and procedure law relating in miscarriage of justice. Lordship, the appellant conviction is based on an incorrect application of legal provision and procedural irregularities. Your Lordship, the application of conviction under section 63 of INS 2023 is legally unsuitable and it is based on incorrect interpretation of rape or on the false promise of the marriage. The prosecution has failed to prove that appellant fraudulently induced complainant into a sexual relationship. Lordship, in Pramod Subramanian Kumar versus State of Maharashtra 2019, the Supreme Court has said that false promise of marriage amounts to rape only if the promise was made with the fraudulent intent. Lordship, here there was no fraudulent intent of the accused because from the first there was voluntary consent of both. They were living in legal relationship and they had proceeded for their wedding arrangement. So here there is no fraudulent intent of the accused. Lordship, in the present,
How will you justify your own conduct? You stay in relationship after that you obtain her consent for promising her that you are going to marry. You would have purchased a flat, taking consideration, half consideration from her. After that, you have sold the property without her consent, and that amount has been deposited in the account of the third person. How you justify your own conduct?
Lordship, firstly,
Why the court should not come and draw a presumption that there is a fraudulent from your part?
Lordship, firstly, when they contributed for the money, there was a thing that she started contributing, but the defendant has contributed by herself. There was no compulsion of him to contribute for the money. He started contributing by his for the future. So it states that there was no force for her to keep the money or to appreciate that for the purpose of the house. Lordship, further, when they moved together, there was no forceful application to move together or live together. They had voluntarily consent. They both had decided togetherly because both are adults. So they had decided completely togetherly to stay together. And whatever the relationship was going on, it was from the both side approval was there. But whatever due to the rejection of marriage, it was due to the extraordinary circumstances, due to the family pressure he has given. And the matter where he has transferred money, it was due to the loss which he has caused, so he has transferred.
In Maya's account. Where come Maya come here?
Lordship,
Amount you have withdrawn and stipended to the account of Maya to whom you were supposed to marry.
Lordship, she
So
was
where is question
she
of
also was
loss
the
and-
employee of the company. So might further they will give that amount or pay that amount for whatever loss has occurred. So further that procedure can be applied.
Next one.
Your Lordship will further move to the fourth
Yes.
issue.
Lordship, with your permission, may I proceed to the issue 4? Much obliged. Lordship, fourth issue was the charge of the rape correctly applied? Lordship, counsel for the appellant must respectfully submit that the charge of rape has been wrongly applied in the present case. The prosecution has failed to establish that the alleged sexual relationship was based on deception or coercion. The relationship between the appellant and complainant as consensual and failure to marry due to circumstances beyond the appellant control rather than the fraudulent intent. Your Lordship, new law INSS ISA came into effect on 1st July 2024. However, the charge sheet and conviction were based on outdated laws, making the entire process was unlawful. Lordship, FIR was lodged on 1st August 2024, meaning the new law should have been applied. But the prosecution wrongly filed the charge sheet under the old law, that is section 376 of IPC, and the punishment was also awarded under the outdated provision. Your Lordship, in criminal law is well established.
You have to
Conclude yourself in 1 minute. Conclude yourself in 1 minute.
Lordship, with your permission, may I submit the prayer? Much
Yes.
obliged. In the light of the facts, issue raised and argument advanced, the appellant must humbly pray before the Honorable Court to first set aside the conviction of the appellant under section 376 of INS 2023 and declare the trial in absentia as unconstitutional and violative the due of process. Second, hold the repeated extension of police remand was unlawful, arbitrary and violation of section 187 clause 2 of INS 2023. Third, hold the charge of rape was wrongly applied or the grant to the other relief the Honorable Court may deem just, equitable and necessary in the interest of justice. And for this act of kindness, the appellant as duty to bound shall ever play. Much obliged, Your Lordship.
Yes, please.
I request Team 24, the respondent, to come forward and proceed with their arguments.
Your speaker number? 1. Speaker number?
Speaker number 1. May it please your honor. May it please your honor.
Yes.
The council seek permission to appear before the court. The council is appearing before the court, before the Honorable High Court in the matter of Rajesh versus State of Aryapur, on behalf of respondent side in response to appeal filed under section 415 of INSS. With the due permission of Honorable Court, I would like to proceed with the pleadings on issue number 1. That is, the appeal is not maintainable before the Honorable High Court. As provided under section, as decided by the Supreme Court judges comprising of Justice Varare and Justice Mehta, that the rape conviction is dismissed by the Supreme Court judges on the basis that prosecutrix, if the statement of prosecutrix inspires confidence, if it is sufficient that it is sufficient in its own to sustain the conviction which was passed by the trial court. Secondly, the judgment of Supreme Court. In this regard, I would like to quote a judgment given in the case of Mahindra versus State of Rajasthan, where Supreme Court has laid down the judgment that we do not want to encourage the absconding for remaining absconded by hearing his appeal on merit, as leniency shown towards the criminal is threat to an innocent person. As Rajesh was trying to abscond from the fair trial, he is declared as an absconder, and if his appeal is rightly maintainable before the Honorable High Court, it would encourage the other absconding, and therefore it will be result in the prolonged period of criminal periods, and therefore the absconding shall not be encouraged by allowing the appeal before the Honorable High Court. With the due permission of Honorable High Court, I would like to proceed with the pleadings on third issue. Much obliged. that is, the lower court's application of substantive and procedural law was appropriate. On this, the council would be establishing 3 grounds. Firstly, the fair application of procedural law, as procedural law provides that whenever a person is absconding from his fair trials, he shall be declared as a proclaimed offender under section 84 of INSS. And also under section 356 of INSS, it is provided that when a person is declared as proclaimed offender, after issuing consecutive warrants, if then also he is not appearing before the court, voluntarily evading from the court trials, a proceeding shall be initiated in the same manner as if he was present in the court. And therefore the trial held in his absentia was adhered to due process of law. Secondly, the fair application of substantive law, as the charges were framed under section 375 of IPC. So the substantive law provides a definition of a particular act which converts as a crime. So act committed by the appellant falls under definition of 375. He had a sexual intercourse with a woman without her consent, and therefore rightly the charges were framed against him, that was according to the substantive law itself. And lastly, the police remand was also as per the procedural law. The police remand was granted not exceeding to the 90 days as required under section 187 of INSS. So it was also according to the procedural law. So the appellant cannot take a defense that the application of substantive and procedural law was not according to the procedure, was not appropriate. With the due permission of Honorable Court, I would like to plead with the 4th issue. Much obliged.
How conviction under section 375 is sustainable when last incident has occurred in the end of July 2024. New act came into force from 1st July. This was a series of incidents, series of events, and in such circumstances, conviction or the prosecution should have been under section 69.
Your Lordship, the substantive law will be applicable under
Therefore, I am asking, section 69 of BNS, that is substantive law,
yes.
which is new provision inserted in BNS. It was not part of IPC earlier. So earlier there was only 375. So how 375 will apply when incident has occurred till July 24, when this act came in force from 1st July. So section 69 should have been applied. Why 375? And how?
Because under Article 20 of Constitution of Indus Land, it is provided that a person cannot be punished for a crime which was not even a crime at the time when he has committed an offence. So when the crime was committed, there was IPC in enforcement. There was IPC in enforcement, and therefore the charges were framed under IPC and not under INS.
Crime is committed till July 24. BNS came in force from 1st July, whereas crime concluded till December, till the end of July. So in such circumstances, new act will apply. Why old act?
Procedural law will be applicable.
No, substantive law.
Just to argue.
Once he has break up the ties, then only issue of complaint arose. Before that, there was no issue of between them. So if that is so, then cause of action for filing complaint has arose on end of July 2024. So it must be case under 69.
I beg your pardon, Lordship. I am unable to recollect right now.
The another issue was that the procedure has not been followed. Though the summons was issued, the proclamation procedure has not been followed. How you justify that? Just your learned brother has argued that.
According to the learned counsel, they held that the proper opportunity was not provided. But as by issuing 2 warrants, proper opportunity not once but twice was provided, but he voluntarily evaded from the trials. As further, they also claimed that the procedure was not followed, but the procedure under section 84 and 356 was duly followed. Therefore, the all procedure was followed. A proper chance to present himself before the court was also provided to the appellant, but still he is voluntarily avoiding from it. So the court can initiate the proceedings. If the court will not initiate the proceeding, it will affect the interest of justice of respondent, and therefore the charges and the claim made by the appellant was not it was false. With the due permission of Honorable High Court, I would like to proceed with the Fourth issue, much obliged, rape charges were correctly applied as defined, on which the council would be establishing two grounds. Consent under section 375 of IPC. So consent under section 375 requires to be free from any misconception of fact. It shall be free from the fear of death or injury. As the consent given by the respondent was under a deception that the appellant will marry with her. So it was not a free consent. It was given on basis of some of the promise. So it was not her free consent, and therefore the act of sexual intercourse without the consent definitely falls under section 375 of IPC. Secondly, the consent on false promise of marriage. Here I would like to quote a judgment given by the Bombay High Court in the Roop Chand son of Dilip Shende versus State of Maharashtra, where the court held that promise of marriage to deceive someone into sexual intercourse vitiates consent, meaning such sexual activity is not consensual. The sexual activity is not consensual when it is given, when the consent was given only on the basis of false promise. If he would have not promised her to marry, she would have not given a consent, and therefore the consent was rightly, it was given only on the basis of deception, and therefore
What is there to show that he had dishonest intention from the inception? That he never wanted to marry the victim and he had this dishonest intention from the beginning itself to cheat her. What is there on record to show that?
as soon as he had a sexual intercourse with her, after some period of time, he took out and he withdrew all the investment made by them together. He also sold out the house purchased by him. It directly shows that only his intention was to having a sexual intercourse with her and not having any intention of marrying with her. If he would have intention of marrying with her, he would have kept that house, he would have tried to convince her parent. But he just used it as a defense for for having a sexual intercourse with her, and after his want is satisfied, he withdrew all the savings and he backed out from the wedding promise.
You are an educated lady, you are 30 years old, you have given a consent when you were residing with that person. You were very well knowing that person, what is his behavior, how he resides, what is his family background, everything you were knowing. When you were residing in a living relationship, at that time also, whatever had happened was happened consensual. After that, when only for a marriage he has denied, you have charges for a rape. No any other charges leveled by you. Why is it so?
As she was residing with him, but previously they were having a good relationship, and therefore they also make contribution. They both are.
Just you said that the consent was obtained, as my senior brother has asked you the questions. On what basis you said that the consent has obtained on a proportion, or consent was a fraudulent, obtained on a fraudulent basis? You had argued that whatever his conduct. So you were very well knowing, despite that, you were knowing that you have been cheated by that particular person. You knowing that whatever amount you have given as a consideration, that has been misappropriated by that person. Despite that, you haven't charges for that particular act. You are only interested to punish him for this particular act, which was consensual. How will you justify that? No any other charges from your part.
We cannot consider that the sexual activity was consensual. It was not her consent by her own will. If the appellant would have not promised her to marry, she would have not given the consent. So we cannot hail it that it was a consensual sexual activity, and therefore the rape charges were framed by the respondent on appellant.
So is it so today if the appellant is ready to marry you, are you going to take all charges back?
Now, respondent would be taking charges back because she gave her consent as they were living together. There was love between them. So, may it please Your Honor, may I proceed with the fifth issue? Extension of police remand is not in violation of constitutional protection. On this, the council will be establishing two grounds. Firstly, the application for police remand. As provided, the grave offence charges were framed against appellant, that is of rape charges, and therefore a 24 hours of investigation process is not sufficient in concerning with the sincerity, privacy of the matter, also the sensitivity of the matter, and therefore the investigation shall be held, a comprehensive investigation shall be held, and therefore the application for police remand was made. Secondly, the extension of police remand was necessary. As the police remand was granted by the lower court, the extension was also much important, because if a hasty decision had been taken by the police investigation, by making a hasty investigation, it would have caused a prejudice to the interest of appellant as well as respondent both, because the rape charges are grave charges to be framed against. It might affect the character even of an appellant. Therefore, the extension of police remand was not in any way in violation of constitutional protection.
But are you going to overlook what is the procedures laid by the legislations? Police custody should not be more than 15 days. But the appellant was there in a police custody for more than 15 days. How you justify that?
He was in the police remand for more than 15 days because the sufficient grounds were there as the charges.
Is there such provisions?
Is it permissible also?
Is it permissible?
Yes, it is permissible under section
Under which section?
356 of INSS.
3.
187 of INSS.
Doesn't say so. There are two words used. One is custody, second is detention. Detention up to 90 days in case of offense punishable by death or life imprisonment permissible. But in that also custody is only for 15 days. So custody and detention you cannot read together. These are two different words, two different connotations.
No police remand can be allowed beyond the period of 15 days.
15 days.
Maximum period is 15 days.
And even on the basis, under this, there is judgment of Karnataka High Court in case of Hyder. It is interpreted that more than 15 days custody is not permissible.
Your Lordship, I beg your pardon. I was not aware of the facts. With the due permission of Honorable High Court, I would like to proceed. I would like to conclude my pleadings by providing a prayer. That it is most humbly prayed that this Honorable High Court, that it may be pleased to dismiss the present appeal as being devoid of merits, to uphold the conviction order passed by the Sessions Court, to uphold the rape charges against accused.
Whether the second speaker is not going to make submission? Second speaker?
No, ma'am.
Shetty sir?
मैं क्या करें?
Collective marks is
असं चालतं सेकंड स्पीकर नाही
नाही ना.
काय करायचं आज पहिल्यांदाच करणार वर्षी. Please, if the second speaker doesn't make his submission, how to assess? Please.
And there's one. There are two more teams.
Have you informed prior that the second speaker is not going to make any submissions? Whether the organizer knows this, or you only decided? Because in a preliminary round you made a submissions. Because this is a collective. We give individual marks. On preliminary ground you made us. Okay, she's not.
Call next time.
Now the next team is team 12 versus team 18. The next team is Team 12 versus Team 18. I request Team 12, the appellant, to come forward and proceed with their arguments.
The council seeks permission to address the bench collectively with utmost respect as your lordship and with due respect to my lady. Much obliged. Your lordship, with due respect, this is counsel 2 appearing on behalf of the appellant before this honorable high court, and with your permission I will be dealing with the starting two. I'm counsel number 2. With your permission, your lordship, I will be dealing with the starting 2 issues, and the rest of the issues will be dealt by counsel, co-counsel. If the honorable bench is well versed with the facts of the case, the counsel respectfully seeks permission to go ahead.
Facts need not tell. Facts is skipping. You can skip the facts.
Your lordship, with your permission, for the convenience of the proceedings, the counsel humbly requests to present the timeline sheets of the event of the case. Much obliged. With due respect, the counsel seeks permission to go ahead with the contentions. Much obliged, your lordship. Your lordship, as issue 1 is concerned, whether the appeal is maintainable before the High Court, it is most humbly and respectfully submitted to the Honorable High Court that the appeal is maintainable before this Honorable High Court under Section 415 Clause 2 of INSS, where it states that any person convicted on trial held by a session judge or an additional session judge or on a trial held by any other court in which a sentence of imprisonment for more than 7 years has been passed against him, then he may appeal to the High Court, as this is a crucial safeguard against judicial errors, ensuring that the accused is given an opportunity to challenge the victim conviction. On page number 9, taking the President on memo of appellant, taking the President on page 9, in Muhammad Sukur Ali versus State of Assam 2011, the Honorable Supreme Court ruled that the right to appeal is an essential safeguard against wrongful conviction, and as the trial in absentia was unjust and procedurally false, making the conviction unreliable. Your Honor, Your Lordship, taking the President on page number 9, in Tara Singh versus State 1951, it was established that procedural lapses affecting fair trial rights provides ground for the appeal. Despite being on bail, he was convicted in absentia without proper compliances with INSS under section 356 and declared as proclamation, which is unjust, therefore making grounds for the appeal. Your Lordship, as taking the President on page 10, wherein Zahira Habibullah Sheikh versus State of Gujarat 2004, it was held that failure to ensure a fair trial violates fundamental rights, making appeal necessary. As the trial in absentia conducted against Mr. Rojesh, the appellant, violated essential due process principles of the Constitution and procedural laws, a conviction in absentia should be the exception rather than the norm, and therefore strictly adhering to procedural safeguards to ensure the fairness that the appeal is maintainable. If there are no more queries, the Council seeks permission to move ahead with issue number 2. Indeed, Your Honor, as there are procedural laws, it is not just about the conviction, but there are the procedural fraud which has been taken place, and therefore as the violation of fundamental rights has been taken place, therefore the appeal is maintainable.
My brother is asking you, when you remain absent, you have not faced the trial. And after conviction you are before coming before this court. Why should we permit you when you are not personally present before the court and filing appeal through your advocate?
Your Lordship, it is not mandatory that always, even in appeal and the cases, always that the case or the appeal is filed regarding the advocate or the counsel, and therefore as filed through a legal counsel, there isn't the necessary provision that the appellant must be present before the highest court. As
Your appeal is filed under section what?
the appeal is filed under section 415 clause 2 of INSS,
So there is a mandatory provision in that. How you justify that provision?
because when any person convicted on trial held by the session judge or an additional session judge or on trial held by any other court in which a sentence of imprisonment for more than 7 years has been passed against him, then he is entitled to the appeal to the highest court.
So what is relevance of section 356 subsection 7?
Indeed, it says that the appeal is not maintainable
Should
if
not-
the...
That provision should not have been there in law then. If your argument is accepted as it is. You are making section 356(7) redundant then.
Your Lordship, as the conviction was held in absentia and the fair trial was not happened, the fundamental laws were violated, and therefore it takes the ground for the appeal.
And therefore presence of accused is made compulsory.
Indeed, Your Lordship, nowhere in the facts of the case is stated that the accused is not present. As the appeal is filed by the appellant on behalf of the counsel, the accused, the appellant is present in the court, Your Lordship. Indeed, Your Lordship, as there are no mentioned the facts that the appellant has not been present, and when the appeal has been filed through the appellant, it's on the behalf of the appellant filed through the counsel, but the appellant is present. If there are no more queries, the counsel humbly seeks to go ahead with issue number 2. Much obliged. Your Honor, as the issue number 2 is concerned, that whether the trial in absentia held other to due processes, it is most humbly and respectfully submitted to the Honorable High Court that the trial in absentia was not conducted adhering to due processes. The trial of appellant which was conducted in absentia violated fundamental principles of due process guaranteed under Constitution of Indus Land. Taking the precedent on page number 11 of memo of appellant, where in the case of Menka Gandhi versus Union of India, it was held that the procedural laws affecting personal liberty must be just, fair and reasonable. As in the current case, Your Lordship, with due respect, the improper proclamation led to an unfair trial, violating the fundamental rights of the appellant. As a trial in absentia can only proceed if the accused is voluntarily present, and therefore it violates the fundamental principles. And also, Your Lordship, with due respect, under section 356, the condition is issuance of 2 consecutive warrants must be there at least in interval of 30 days. Where, as Your Lordship, with due respect, as the timeline is being presented towards you, it is there that indeed the consecutive 2 warrants was there, but it wasn't in interval of 30 days of period, as the first consecutive warrant was given on 1st December 2024, and soon after on 28th December 2024 the second consecutive warrant was given, which completely violated the section 356, where it is provided that issuance of 2 consecutive warrants must be in at least in interval of 30 days. Adding to this, with due respect, Your Lordship, as the appellant was convicted in absentia, it was not actually a fair trial. And under section 356 of INSS, court shall not commence a trial unless a period of 90 days has lapsed from date of filing the charge sheet.
Why did you not challenge the warrants that were issued against you? Why did you not challenge the warrants that were issued against you? Why did you not challenge the warrants that were issued against you? The warrants that were issued against you, why did you not challenge them?
Your Honor, the warrants was not commenced to the appellant, and it wasn't in the due time, it didn't reach to the appellant, and therefore he wasn't aware.
Report says it was served on you. 2 consecutive warrants served upon you. That is
Indeed.
what the report is.
Indeed, Your
So
Honor.
how you can take benefit of your own wrong now? How you can permit it to take benefit of your own wrong? You remain absent in the trial. You are proclaimed as absconding. And now you are saying that procedure is not followed. So you are taking benefit of your own wrong.
Your
Because
Honor,
you were in custody for 90 days. You were knowing that trial is pending against you. Then how you will justify this?
Your Honor, as the appellant was continuously tortured under 90 days of custody, he was not absconded but he was scared. He was afraid and he was there to save his life, and he was not absconded but he was there saving his life, and therefore he didn't preach. And it could be the personal grudges of the police that the warrants and summons were just issuing of warrants and summons cannot be convinced that they were reached to him, as they were not.
What threat you had coming before court? What kind of a threat you had to come before court?
Because you were not supposed to go before the police.
What prevented you from coming to the court?
Preventions?
What prevented you? What stopped you from coming to the court?
Your Honor, as the appellant was tortured in the custody, therefore he was hiding till then, and therefore he was saving his life till then. As he needed time to overcome his harassment and his mental pressure, and soon after he overcome and he needs the justice, Your Honor, therefore he has now been filed the appeal. Your Honor, as the timeline is commenced, the charge sheet was filed on 16th of November 2024, but the trial soon was commenced in February 2024, which doesn't come under the lapse period of 90 days, and therefore the trial in absentia was not other to due process. With this, the counsel too would like to conclude with the two contentions. The counsel too is grateful for the Honorable High Court and the valuable time given. Much obliged. Much obliged, Your Lordship. Your Lordship, this is counsel number 1 from the appellant side will be dealing with the rest of the contentions. With your permission, I shall begin with the rest of the contentions. Much obliged, Your Lordship. Issue number 3, that the lower court's application of substantive and procedure laws were inappropriate. In Uday versus State of Karnataka on page number 13 from the appellant's memorial, the Honorable Supreme Court of India emphasized that the mere breach of promise cannot be equated with the consent obtained under false pretense. There is no evidence, Your Lordship, that shows that Rojesh never intended to marry Ria. The charge of rape under section 375 read with section 376 requires proof that the sexual act had happened without the woman's consent and that the consent was obtained under false pretenses. Ria's consent, Your Lordship, was genuine from the starting itself and was initially given on the promise of the marriage, which couldn't be fulfilled due to the breakdown of their relationship, and that does not automatically invalidate the consent given before. It is crucial, Your Lordship, to distinguish between the breach of promise and a false promise, where a breach of promise occurs when there is a genuine intent to fulfill the promise, but later due to certain circumstances the person could not fulfill it. But the false promise, on the other hand, was flawed from the starting itself. Your Lordship, the trial in absentia was conducted without ensuring that the appellant had actual knowledge of the proceedings and reasonable opportunity he was not having to defend himself. It is humbly submitted that the application of law by the lower court was inappropriate. Issue number 4, was the charge of rape correctly applied? Your Lordship, in Dhruvara Muralidhar Sonar versus the State of Maharashtra on page number 15 from the appellant's memorial, the Supreme Court held that if the promise of marriage was bona fide and there was a genuine intention to carry it out, the subsequent failure to marry does not automatically render the consent invalid. The breach of promise does not automatically equate to false promise made at the beginning of the relationship. Your Lordship, relationship gone sour cannot be treated as a criminal act. Rojesh initially wanted to marry Ria, but due to the changing circumstances, he couldn't marry, and the evidence such as their cohabitation and the joint purchase of the house are the evidences that he initially wanted to marry her. Your Lordship, initially the arrest was made under section 69 of the BNS, and later the charge sheet was filed under section 375 and 376 of the CRPC. Your Lordship, the punishment between both of these sections have a drastic difference, where under the BNS the punishment is given not exceeding than 10 years and fine, but in the CRPC it is 7 years and can extend up to the life imprisonment. There is a drastic difference between the punishment. That means the police had some bad intentions and grudges towards Rajesh. That is why they wanted him to stay in prison for long. And also, the final charge sheet was filed between a very short period of 10 to 15 days after the bail was granted, and the same investigation which was completed in this short period of 10 to 15 days could not be completed in the whole 3 months when he was in remand. So this is a very important question, that there is something a very unlawful thing involved, and the police might have been bribed to indulge into this illegal act. The external pressure from his parents and his deteriorating relationship with Ria may also have forced him to take such decision to marry Maya. Your Lordship, the Council requests this Honorable High Court to set aside the conviction and acquit him of the rape charges. Your Lordship, one more point to be added is that Rajesh ended his relationship in July. So if she was concerned about the marriage, she could have filed the FIR immediately after their breakup. But she didn't file the FIR at that time. She filed the FIR when the house was sold. So she was clearly interested in the money and not in the case of rape. Your Lordship, with your permission.
Conclude yourself in 1 minute, then we will pose a question.
Your Lordship, if you permit, there is last issue that I want to conclude in few seconds.
See, you may get negative marks also.
Okay, Your Lordship, with your permission, I shall continue with the prayer.
How will you justify your subsequent conduct, as you argued that there was an intention to marry her? But what about the subsequent conduct? You have sold the property, you have siphoned entire amount, the consideration amount which was given by the Ria was transferred in the Maya's account. How you will justify your own wrong?
Indeed, Your Lordship, these are the facts that has happened, but due to the frequent quarrels between them both, he was frustrated and the relationship was not working. So he thought of moving on, and the house was jointly purchased. He might have thought to sell it, and it is possible that he could have communicated. But instead of communicating with him, she immediately, after acknowledging that the house is sold, directly filed the FIR to take the revenge under frustration. So she didn't even communicated with him. There are chances that he could have shared the profits with with her also. Much obliged.
Your prayer, please.
Whereof, in the light of the arguments advanced, the appellant most humbly prays before this honorable court that it may be pleased to hold the appeal is maintainable before this honorable court, declare that the trial in absentia was conducted in violation of due process and the constitutional safeguards rendering the conviction void ab initio, purge the conviction under section 376 of Indus-Land Penal Code and set aside the sentence of life imprisonment, declare that the extension of police remand was unlawful and in violation of fundamental rights, thereby invalidating any evidence obtained therefrom, grant such other and further relief as may be deemed just, equitable and necessary in the interest of justice, all of which is most humbly prayed counsel for the appellant.
I request Team 18, the respondent, to come forward and proceed with their arguments.
Your speaker number?
Speaker number 1, English. The council would like to collectively address the benches, Your Lordships. Much obliged. Your Lordship, due to this paucity of time, the council seeks permission to proceed with the issues.
Yes.
Much obliged. Your Lordships, as speaker number 1, I will be dealing with the first 3 issues and my co-counsel will be dealing with the rest 2 issues. Much obliged. Your Lordships, the first question in hand is related to whether the appeal is maintainable in this court or not. The counsel for the respondent would humbly like to contend that the appeal be dismissed summarily because there is no merit or substance in this case, as all the procedures were rightly followed, because the criminal appeal in this court was filed by challenging the trial, the handling of the remand proceedings and the conviction by the Court of Sessions, all of which were done judicially by applying the mind of the Honorable Court. So therefore, the Council would contend that if the Honorable Court would please summarily dismiss this case due to lack of merit and substance. Much obliged. If the Council could proceed.
According to you, what remedy the appellant had? If
Your
the appeal
Lordship,
is not maintainable.
Your Lordship, he was a proclaimed offender in this case. He was given not just one or two opportunities to present his defense in the Court of Justice, but he had denied, and according to section 356, he has waived off his rights to be defended.
So you want to say that proclaimed offender has no right to file appeal?
No, it's not the case, Your Lordship, but in this case, he had willfully, absconded. He was evading the trial. Because of his absence, the police were not able to execute the two subsequent warrants that were issued against him. And moreover, Your Lordship, there is no legal substance that it is existing for him to defend himself in this Honorable Court. Because he would have done that.
Take a case. After his release on bail by way of default bail, he might have been taken in custody in some other state for some other offense. He was there for 1 or 2 years. Subsequently, he realized after release from that court, he came to know that he is wrongly convicted by the first court. Can this court remand the case back? In such circumstances it is possible?
Your Lordship, the facts are silent about this particular aspect. But then if taking into consideration this thing, the Sessions Court judge would have also taken into consideration, applied his mind in such a way that all of these facts and circumstances are taken into consideration. But since the facts of the present case is silent about the same, the Council would not be able to contend for this.
What are the powers of this court to remand the matter back in view of there being a procedural irregularity or the due procedure not being followed?
Your Lordship, the Council acknowledges and is aware that the High Court has the supervisory and review jurisdiction within its capacity. The Council has no doubt regarding the same. But here the appellant has no substance in his case, no merit. He lacks all due things that he should approach this court. Waste the time of this honorable bench where he has waived off his rights. So the Council would...
So if you agree that there is power of review vested with the criminal courts, do you want to say that?
Of course, Your Lordship, I'm not denying the same.
So can they go before the same court by filing review and requesting the court to set aside the conviction? Is that can be done in criminal law as like civil law?
In the, I'm sorry, Your Lordship, could you repeat the question again?
Whether the criminal court has power to review its own judgment, as you have said that this court has power of review.
This High Court has the supervisory jurisdiction as well as a review jurisdiction, Your Lordship.
Supervisory jurisdiction is under Article
227, yes, Your Lordship.
So this is not a case under 226 or 227. It is case under Section 415 of BNSS, wherein statutory appeal is provided.
Yes, Your Lordship.
So there is no question of supervisory jurisdiction. This is appellate jurisdiction, and appellate jurisdiction we have power to remand the matter, as my brother has suggested.
Yes, Your
The
Lordship.
question is whether there can be review of the criminal judgment by the same court. That is what the question is. And does it permitted under either CRPC or BNSS?
Your Lordship, the Council would seek a minute's permission to just look through the things.
Proceed further.
For the contentions? Okay, Your Lordship. Your Lordship, the Council would seek permission to proceed with issue number 2.
Yeah.
Your Lordship, the issue number 2 is related to whether the trial that took place in the absence of the appellant is against due process or not. Your Lordship, it should be noted that the legislative intent in incorporating such a section, which was absent in the colonial law, is after they have considered that there are a handful of fugitive offenders who evade trial, they abscond themselves just to tie the hands of the criminal justice procedures, and they think that when they are declared a proclaimed offender, the case will be filed under long pending case, and then the case will drag till they are arrested and produced before the court, Your Lordship. The intent of this section is that when a proclaimed offender, he is willfully absconding himself, evading the trial, not presenting his defense in front of the court, and if the judge is satisfied with all of these things, it is considered that he has waived off his right to be heard, and the court is empowered and also is mandated to proceed with the trial and also pronounce the judgment. So in this case, he was given opportunity. The natural justice principle, which is the odi altrum partem in this particular case, it is saying that no man shall be condemned without being given an opportunity to be heard. Here, clearly, Mr. Appellant was given opportunity, not once but multiple times. Summons were given, warrants were issued, but it was not being executed just for the reason being that he was absconding and the police were not able to find him. And Your Lordship, it has been contended by a lot of courts and upheld and also taken into account that the natural justice principle cannot be a bracket rule. Depending upon the situation and the type of case the court is dealing with, we will have to alter the odi altrum partem. And here, the statutory provision in itself is empowering and mandating the court to proceed with the trial and also give the pronouncement of the judgment in the absence of the accused. So there shall not be any question with respect to whether the trial in absentia is right or not, because the statute in itself is giving the power, and also we have procedures given. So that will not vitiate the entire trial that took place in the absence of the accused, and this shall not be the grounds under which he is trying to completely disqualify the validity and legality of the proceedings, because everything was taken care of by the Honorable Justice of the Sessions Court by taking into consideration all the procedural mandates that were put on via the INSS, Your Lordship. Your Lordship, here the appellant has clearly tried to play with the criminal justice system, as he had clearly manifested that the judges and the court would be tied, and everything is depending upon his willingness to appear in front of the court or not, Your Lordship. If Your Lordships are satisfied with the arguments, the court's counsel will take it. Much obliged.
With Your Lordship's permission, Council would proceed with issue 4 and issue 5. Your Lordship's issue 4 is regarding whether the charge of rape was applied correctly or not. It is humbly submitted before this Honorable High Court of Aryapur that the appellant is rightly charged for the offence of rape, as the essentials under section 375 read with section 90 are complied with. Your Lordships, since this court is considering, this case is in regardance with the rape due to the false promise of marriage, we will be reading the section 375 along with section 90. Your Lordship, section 90 per se does not talk about consent, but it does talk about what is not consent. Your Lordships, my learned opponents have been saying that the Ria had her consent and the consent was fully given by her own. Your Lordships, the consent as per section 90 is not a consent when it is given by a person because of fear or injury or under misconception of facts. Your Lordship, this case is totally based on misconception of fact. As said in Pramod Suryabhan versus State of Maharashtra, to establish whether a consent is vitiated by a misconception of fact, it has to be complied with two propositions, and they are that the promise of marriage must be false promise given in bad faith from the initial stage, and the false promise must itself be of immediate relevance and bear a nexus to the woman's decisions. Your Lordships, as held in Anurag Soni, we can rightly say that the consent given here by the prosecutrix on the misconception of fact arisen from the false promise of the marriage which was never to be complied with.
What was the misconception of that to be?
False promise of marriage, Your Lordships.
Why did she use a false promise?
Your Lordships, I will take you through that, Your Lordships. Your Lordships, there had been many instances. The Apex Court has time and again differentiated between false promise and breach of promise. False promise, whereas when a promise that is given in a bad faith at the initial point and has no intention to be complied with, and breach of promise is when the promise is given in a good faith, but still because of some circumstances it would be impossible to fulfill it. Your Lordships, there is no presence of substantial fact which shows that the promise to marry would become impossible by the accused. Your Lordships, I would take you through the important events which led to the false promise, which led to the conclusion of false promise. Since the beginning, the accused has expressed the intention to marry, and later he made her believe into his false promise, and to make her believe he started saving money. And falling prey to his whole idea of this, the prosecutrix also started giving money, started contributing significantly, and later without her consent or without her knowledge, he withdrew the money and put it into an account which was a joint account with another woman which he was marrying later, which he claimed to be a very arranged marriage by his parents under their pressure. Later, Your Lordships, both of them purchased a house on the name of the accused, and they were sharing the loan payments. And later, the same house was without the knowledge and any kind of prior information to the prosecutrix, was sold, and the proceeds of the house were again transferred to the same account, to the joint account with the another woman. Your Lordships, in spite of assuring commitments multiple times, even after proposing her to marry and committing himself into the sexual relationship, after getting pressurized from his parents, he simply asked them to find a suitable partner. Your Lordships, there is no substance, there is no legal substance that he tried to convince his parents, Your Lordships.
No, but then initially when the promise was given, it was given in good faith it seems, because later on, because of the pressure of the parents, he had to
Withdraw.
Your Lordships, they met at a social event, Your Lordships, of investors on 15th May, where he gave a lucrative position in his company. And later, Your Lordships, the accused had the only intention since the beginning to take advantage of the prosecutrix financially as well as sexually. Just after getting done with his sexual needs, he sold the house, as well as he took out the money and transferred it to some other account. And then later, after that only, he started getting away from the prosecutrix. Why did that happen, Your Lordship? If he had good intent, he wouldn't have done that. It was not only the pressurization from their parents, it was his own intent that was not made in good faith. Your Lordship, the accused has deployed marriage as a tool to convince the prosecutress again and again whenever she had any doubt.
One question for you.
Yes, Your Lordships.
Offense is initially when law was set into motion, there were 3 allegations.
Yes, Your Lordships.
First allegation was of rape,
Yes,
second
Your
was of domestic violence, third was of exploitation. As there is separate charge of rape, we have to take that exploitation is financial exploitation. So, as far as case is concerned, you live together, so you were in live-in relations. You were in live-in relations, therefore only domestic violence was applied. So once you are accepting that you were in live-in relations, there is a violation of domestic rights, so there is domestic violence. How offense under 375 and offense of rape we maintain against the accused?
Your Lordships, live-in relationship...
Because both cannot go simultaneously.
Your Lordships, indeed, but the live-in relationship, consent to a live-in relationship does not directly, by default, give a consent to a sexual relationship. She gave the consent to a sexual relationship only after getting totally assured by the accused that he would marry her by the end of 2024, that is next year. And that happened after he slapped her, Your Lordship.
just to make up the things again right, to make the things right on the surface, he kept giving assurances. Yes, Your Lordship. If Your Lordships are...
How
yes.
the IPC will apply? How the IPC will apply here? Why you have been punished under section 375 of IPC? This
Your
is a
Lordships,
continuing offence.
Your Lordships, the offence was committed before the enforcement of the Act, Your Lordships. So since it was committed before the enforcement of the Act, the old Act will be taken into consideration for the substantial laws. And for procedural laws, new acts will be taken into consideration, like INSS has been taken into
It has
consideration.
started before commencement of new act and ended after commencement of new act, because July end is the date of last incident. Then why not BNS will apply?
Your Lordships, the act was committed, the offence, the act was committed prior the commencement of the new act, Your Lordships. Since that is why we are taking the old act into consideration, that is IPC. If Your Lordships are convinced, I'll move on to the next contention.
No, you have
Come to the
conclude
prayers
yours.
only. Your time is over.
Okay, yes, Your Lordship. Prayer. In the light of the facts of the case, issues raised, arguments advanced, and authorities cited, the counsels on behalf of the respondent humbly pray before this Honorable High Court of Aryapur to kindly adjust and declare that the appeal is not maintainable, before this High Court, that the trial in absentia adheres to the due process, that the lower court's application of the substantive as well as procedural laws is inappropriate, that the charge of rape is correctly applied, and that the repeated extension of police remand is lawful and considered all the constitutional protections, and or pass any other order that the bench deems fit in the best interest of the justice, equity and good conscience, and for this act of kindness the counsels on behalf of the respondent as in duty bound shall forever prove. Thank you, Your Worship.
Only 14.
So we have 21, 22 we have disconnected. 22,
I told
24.
Now the issue.
Team 24.
Female selection. Male होता है.
They have done both. Through advocate leader. So that is a grey issue. 356(7) is clear. नहीं 356 मध्ये even after नहीं मग आता या केसमध्ये consider individual also. Okay, so that girl is from your policy. Then, okay.
All rise. Everyone is requested to be in the seminar hall. The results will be declared shortly after.